Welcome to this explainer. Okay, today we're going to dive into one of the most complex, emotionally charged, and honestly, heavily bureaucratic spaces in our entire society. We're talking about that very delicate intersection where family law collides with the state child welfare system. Specifically, we'll be taking a look inside the Indiana Department of Child Services, or DCS. It's this fascinating world governed by incredibly strict statutory mandates on one side and the deeply messy, complex reality of human lives on the other. All right, let's just jump right in. Take a look at this tense, real-world exchange between a DCS caseworker and a mother. The caseworker flat out states their absolute legal mandate. My job is just to ensure that the children are safe, right? But then the mother's response is so revealing. She says, I filed a protection order, and it was granted to me and my family. Instantly, you can see this incredible friction between a systemic, bureaucratic mandate to investigate and the lived reality of a family who is already trying to protect itself using the civil court system. So here is our roadmap for today. 1. The child welfare mandate. 2. Assessments and evidence. 3. A case study on the Pearson family. 4. Appeals and record retention. And finally, 5. Systemic gaps and solutions. Okay, Section 1. The child welfare mandate. Rules of the game. Under Indiana Code, the agency actually went through a massive philosophical shift recently. They moved completely away from conducting purely punitive investigations and shifted to what they now call assessments. Now, an assessment isn't just about pointing fingers or looking for someone to blame. It's actually designed to be an evaluation of family needs. The ultimate goal is to look at the functional strengths of a family unit and figure out exactly what formal or informal supports are required to safely keep that child in the home, basically mitigating any future risks. Now, you might be wondering, how does the state possibly manage that kind of massive responsibility? Well, enter the MAGIC system. That stands for the Management Gateway for Indiana's Kids. Think of it as the ultimate digital footprint for families caught in the system. It's the first thing caseworkers check the second a hotline call comes in. It is this highly confidential, centralized electronic database that tracks every family's history, providing immediate context. And it's not just a digital filing cabinet either. It's integrated with financial systems like KidTracks, and it actually hosts the Child Protection Index, which is a statewide registry of substantiated abuse. It's literally the technological backbone of the entire child welfare apparatus. Moving on to Section 2, Assessments and Evidence, Meeting the Threshold. So the culmination of every single DCS assessment is a document called the 311 report. And let me tell you, the protocol for this is incredibly strict. Family case managers are trained to only use objective nouns and verbs to describe behaviors. They have to explicitly avoid value-based adjectives. So they can't just write, the house was messy or the parent was mean. They have to objectively document the cold, hard facts so that supervisors and eventually judges can make clear, legally sound decisions. And this is absolutely crucial, because even a single subjective adjective could unfairly alter a family's legal fate. Ultimately, all these allegations end up in one of two main buckets: substantiated or unsubstantiated. Substantiated basically means there is a preponderance of evidence. Mathematically speaking, that's a probability of just over 50% that abuse or neglect occurred. Notice that this is a civil standard, which is a much lower bar than the criminal standard of beyond a reasonable doubt. But here is the really critical distinction. Unsubstantiated simply means the civil burden of proof wasn't met. It does not necessarily mean a report was definitively false or maliciously made. It just means the state couldn't formally prove it to that required legal threshold. All right, Section 3, the Pearson case study, theory meets reality.
Let's zoom in on a real-world example. Over the course of a single year, the Pearson family had two entirely separate DCS assessments. In September 2024, there were allegations of neglect, unsubstantiated. Then, in May 2025, there was a specific report of neglect involving exposure to domestic violence, where the mother even had a visible head injury. Yet somehow, this was also unsubstantiated. So by August and September of 2025, the mother, Megan, decided to bypass the child welfare system entirely. She filed for civil divorce and was granted a formal protection order directly from a judge.
Now, what's really interesting here is that these are the actual civil court documents Megan filed to legally protect her family. Because DCS could not substantiate the allegations under their specific legal framework, the state's intervention basically hit a brick wall. Megan had to step in herself, using civil family law to build a safety net that the child welfare system simply could not legally provide for her. Which brings us right back to that audio quote we started with. Shortly after the protection order is filed, a new hotline call comes in, triggering another DCS assessment. and we get this fascinating, tense conflict. Impartially speaking, both sides here are doing exactly what they believe they are supposed to do. The DCS worker is legally mandated to lay eyes on the kids to ensure basic safety. But the mother, who is completely exhausted by past unsubstantiated assessments that left her vulnerable, is fiercely asserting her valid protection order. She refuses to let the caseworker in. She is prioritizing her own carefully constructed legal safety plan over just another state assessment. And the mother's actions here tie directly back to DCS's own domestic violence protocol. See, DCS doesn't just look at the offender. They also evaluate the non-offending parent's ability to ensure child safety. If a parent fails to protect a child from domestic violence, they can actually be substantiated for neglect. So Megan's aggressive pursuit of civil protection orders is a vital piece of the puzzle. She's actively demonstrating to the state that she is protective, which, in her eyes, makes any further DCS intervention legally unnecessary. Okay, Section 4, Appeals and Record Retention, the long tail of DCS. Guys, the record retention rules for this system are absolutely staggering. If an assessment is substantiated, those records are kept for 10 years. But get this. Electronic records of unsubstantiated cases are kept in the MAGIC system for 24 years after the birth of the youngest child. 24 years. That means even when the state finds absolutely no preponderance of evidence, that file acts as a historical anchor for decades, and it's completely visible to caseworkers if the family is ever reported again. Expunging these records is this massive legal battle, requiring either a juvenile court petition with clear and convincing evidence or a direct request to a deputy director. Finally, let's look at Section 5, Systemic Gaps and Solutions, Rebuilding the Safety Net. So what's the fix? Well, one of the single biggest protective factors for a family in crisis is housing. By utilizing the coordinated entry system to double rapid exit housing vouchers, taking them from 6 up to 12, authorities are realizing they can have a direct, tangible impact on child welfare. Think about it. When a non-offending parent actually has a safe place to go, caseworkers don't have to substantiate them for environmental neglect. Stable housing is literally a shield against state intervention. And that leads us to this truly striking statistic: 15%. To put that into perspective, despite completing more child protection assessments than almost any other state in the entire country, Indiana only substantiates about 15% of them. That means the front door of the system, the hotline, is wide open, but the evidentiary threshold for formal state intervention is incredibly narrow. This just floods caseworkers with assessments that rarely result in any kind of formal action. So the strategic outlook to fix this has to be multifaceted. We need to enhance the MAGIC system so supervisors can actually see these regional data trends. We absolutely have to firmly integrate DCS with housing systems, just like we discussed. We also need to streamline that 24-year expungement process because families shouldn't be shadowed by unsubstantiated reports for decades. And lastly, the system has got to close the supervision gap for domestic violence, offering real, non-punitive support for families way before these issues escalate into tragedies. To wrap up this explainer, I want to leave you with a real thought-provoker. How can a child welfare system successfully balance the absolute mandate of child safety with the trauma of systemic intervention? It is an incredibly delicate tightrope walk between protecting vulnerable children and respecting the lived realities and rights of families in crisis. I really hope this deep dive gave you a clearer understanding of exactly how that balance is struck every single day. Thanks so much for hanging out and learning with me, and definitely keep asking the hard questions.